Thank you again, JP. In this segment, I'd like us to deal with the Chief Justice nomination. But before we get there, I need to follow up on the last judicial activism question that we discussed in the previous segment. There is a judgment of the Constitutional Court, the so-called secret ballot judgment.
Right.
Now, I understand that in that case, the then Speaker of Parliament took the view that she doesn't have the power to, as I recall it, to order secret ballot.
Yes.
Or not to order secret ballot. And so she took the view that she was powerless. And the Constitutional Court simply pronounced that, no, you are not powerless, you can make the you can make the decision. Now, in a case like that, if a party had gone to court, as I thought was the intention of at least some of the parties,
yes,
to force the Speaker
to hold a secret ballot.
To hold a secret ballot, would you say in those circumstances, a court has that power to make such an order?
The court could have inferred such power from the statute itself or from the rules that govern the National Assembly, and in line with the activist approach. If the court was so minded, it would use those rules and the statute and say, Speaker, it's all within your power to do so. Whereas a court which is exercising judicial restraint would say, no. We are deferring to the Speaker. Let the Speaker decide what to do. That's the difference.
Yes, except I'm asking a different question for a reason. That is what happened in the Constitutional Court.
Yes.
Where the Speaker said, I don't have the power, the Constitutional Court said, you do have the power.
Yes, that was an activist approach
Yes.
in my view.
Now, what I'm asking is this. If the question put to the Constitutional Court, or the order that was sought, was for the Constitutional Court to direct the Speaker, not to make a declaratory order that the Speaker has such power, but to direct the Speaker to allow for secret ballot.
Right.
Does a court have such power if the Constitution, the rules, and the rules of Parliament, and that act with a long name, Powers and Privileges of Parliament Act and so on,
That's right.
are silent on which procedure should be followed? Does the court have the power to order such?
I think it would depend on the proper interpretation of the legislation. I do not have the legislation in front of me. But in principle, nothing stops the court. On a proper interpretation of the Constitution, the relevant legislation and the applicable rules relating to the National Assembly, nothing would have stopped the court from saying, you go and exercise your powers in this particular fashion.
No. Would it have the power to instruct the Speaker of Parliament to have or to decree voting by secret ballot, is my question.
Would the court have such power?
Would the court have the power to instruct the Speaker to decree that there must be a secret ballot in deciding on whether or not there is, I think, a vote of no confidence in the President? Granted, if all the prescripts are silent as regards whether the vote should be by secret ballot or by show of hands.
There again, one has to be careful. The dividing line between activism and usurping the powers of Parliament can be very, very thin. In a situation like that, I would argue if the Constitution is silent, the relevant applicable legislation is silent, and the rules of Parliament are also silent. All the court should do is that, Speaker, please go and apply your mind as to whether or not, in a situation like this, you as a Speaker should allow voting to be by secret ballot. I would be reluctant as a judge in a situation where the Constitution is silent, the relevant statute, regulations, and the rules of the National Assembly are all silent to direct the Speaker to do that. We have to be
All
careful
right.
to balance the two
Yes.
and not go too far in an effort to show or to demonstrate that we're activists, because
All right.
we end up usurping the powers of the
Yes.
legislature. And
All right.
often Parliament is silent deliberately because it did not want that to happen.
Yes.
And you don't expect the legislation to say, no, there shall be no sick parrot at all times.
All right. Thank you, JP. Now, the controversial issue. Well, controversial depending on which side of the fence
Yes.
one sits. There has been criticism by some academics
Yes.
and some legal practitioners, including the chairperson of the General Council of the Bar, who wrote an opinion piece in one of the publications.
Yes.
He was criticizing the Black Lawyers Association for nominating you to stand for the Chief Justiceship of South Africa, because he says there is a cloud hanging over you, that you're facing impeachment for interfering allegedly with two judges of the Constitutional Court and so on. Now, although the article focused, I'm using this simply as a reference point, I'm not
That's
personalizing the attack to him, right? Because he expresses a view that is held by some practitioners. I hesitate to say many or most or few, but some practitioners hold a similar view.
Right.
They say that you should know better, you should have a better judgment than to accept a nomination in circumstances where you are still facing possible impeachment. What do you say to those people?
First of all, Mr. Ngalwan, I'm not the only judge who has been nominated who is facing discipline at the hands of the JSC. There are other judges who have been nominated who are facing similarly charged with serious gross misconduct, who are facing disciplinary action before the JSC. I'm grateful to
Wait, sorry, JP, before you, like who? Are you happy to share the names? It should be in the public domain, or hasn't it reached that stage yet of these other judges?
I'm aware of the fact there are complaints against Judge President Mlambo. He knows that, right? But somehow it has not reached the public domain. He knows that. There are complaints pending against him.
Okay, but that hasn't reached, I wasn't aware of that, but that hasn't reached the Judicial Conduct Tribunal stage where
Yes.
a finding, an actual finding is made of gross misconduct against him. So isn't his case different from yours?
Perhaps his case is different from mine in the sense that mine has advanced to where we are.
Yeah.
But let's put a context to the complaint against me. It happened almost 14 years ago. At that time, there was a vacancy for the position of a Chief Justice. And every legal practitioner, everybody in legal circles was saying, Hlophe is the man. They blocked me. 2011, there was a similar pattern. And now that Chief Justice Mogoeng has retired, we are seeing this resurfacing. So there is a pattern. Whenever there is a vacancy for the position of a Chief Justice, I'm pushed under the bus. Now, as to why I personally accepted the nomination, first of all, I do not believe that I did anything wrong. I have been found guilty, as you know, Mr. Ngalwan. But let's go back. On the 29th of September 2009, I was cleared by the JSC. It found no evidence of wrongdoing on my part. Right? Nothing has changed between then and now, other than the composition of the tribunal. You remember, after I was cleared, you had the interlopers, the politician, and the retired judge Johan Greckler, who wanted to push me under the bus. They challenged the proceedings before the tribunal which cleared me on the basis that the Premier of the province, Madam Helen Ziller, was not part of the panel. The matter went all the way to the Supreme Court of Appeal, and that challenge was upheld. So where I come from, I believe I am innocent, number one. I have said this before, and I was cleared. And I have no doubt when the appeal reaches Parliament, I will be vindicated one day.
Well, lawyers will say you were not quite cleared because all the, was it the Judicial Conduct Committee?
It was the tribunal.
Was it the tribunal?
By a majority of 2 to 1, I was
Yes.
cleared in that regard.
Some lawyers would say that falls short of clearing because all it did was to say this is not sufficiently serious offense to be referred to, I mean, to be, to find that you had committed a gross misconduct.
That's right.
And thereafter, as is the process in law, one reviews a judgment. And if it is set aside by a higher tribunal, then one can't say one was cleared because it was a stage in a process. What matters is the final decision of the final court. What would you say to that?
Well, Mr. Ngarana, the truth of the matter is this: I was cleared. What happened when the matter went to court, the decision of the tribunal was set aside because the Premier was not part of the panel. In other words, it had to do with composition. The court took the view that the proceedings were fatal. The proceedings were fatal in as much as the Premier of the province did not form part of the panel.
Yes.
That was the finding of the court. Other than that, I was cleared. There was no evidence of wrongdoing on my part.
Wasn't there another process, another challenge, apart from the Premier of the Western Cape one? Didn't the, I think it's called freedom under law,
Yes.
on what basis did they challenge the decision? Because theirs, I don't think, was based on the proper
On composition.
the proper composition of the JSC. What was the basis for their challenge?
I do not remember what was the basis for their challenge, but freedom under the law also entered the fray, right? Basically to support the position that was taken by the Premier of the Western Cape. But never mind that. Ask yourself the following question. What has happened 14 years later? Right. One would have thought in a situation like that, if I was cleared 14 years ago, we look at the evidence now. The SCA directed that there must be cross-examination on certain aspects. I appeared last year publicly. I was cross-examined. There was no suggestion that I did not fare well in cross-examination. I withstood cross-examination. There were even favorable credibility findings, in my view. But notwithstanding that, and notwithstanding that the evidence of the 2 judges, Jafta and Gabindo, who are not complainants, by the way, they are on record as saying they are not complaining, notwithstanding that their evidence totally disintegrated. They even changed their version. Right? Notwithstanding all of that, I was still found guilty. The answer is simply this. The composition of the panel changed. It's no longer the old panel. It changed. You have 2 members of the panel. You have new panelists altogether. That was the only change.
Wasn't it part of the freedom under law? My recollection is a bit rusty, so you correct me if I'm wrong. Wasn't it part of their challenge that the JCT acted irrationally, or their majority acted irrationally in saying that your conduct was insufficiently serious to warrant impeachment?
Yes, I think you're right, Mr. Ngalwana. That was the FUL's argument.
Yes.
And the matter went all the way to the Supreme Court of Appeal. And the Supreme Court of Appeal analyzed the record and directed that cross-examination should take place in respect of certain aspects.
Yes.
I went there last year. I was thoroughly cross-examined on those aspects. And I believe I did well in cross-examination.
Yes.
And that's why when the finding was made that I was guilty, it was shocking to say the least.
All right. Let's continue in this vein in the next segment. I just want to probe a few other issues before we move on to the next
Sure.
issue. Thank you, JP.